A very good afternoon to everyone. On behalf of MICCI, I thank you for tuning in to this very timely webinar, which will be touching on personal data protection, data security, and personal freedoms in the context of COVID-19 pandemic. Ladies and gentlemen, this webinar will take approximately about 1.5 hours. We would like to encourage our viewers to log into our Facebook and to submit your questions and queries as we go along through Facebook Messenger. And we will try our best to address them during the Q&A sessions. We are very fortunate today to have two very distinguished speakers, Dr. Munyati of ISIS Malaysia and Ms. Lilin Lee of Tay & Partners, talking to us respectively on COVID-19 apps, privacy and security. And Ms. Lee will be talking about data privacy in the context of COVID-19 pandemic. Ladies and gentlemen, our speakers will be speaking for about 20 minutes, and thereafter we'll be opening for Q&A sessions after both speakers has finished their presentation. Our moderator for today is Mr. Lee Teng Kiat. Mr. Lee is the managing partner and founder of Mrs. Lee and Tengku Azrina, a legal firm located in Johor Bahru. Mr. Lee is also currently our General Committee members of MICCI, and he is also the Vice Chairman of our MICCI branch in JB. Mr. Lee has wide experience in various areas of law, ranging from corporate and commercial financing, property and dispute resolution matters. Mr. Lee has also represented a large number of local and foreign corporations, developers and banks in Malaysia on various deals. Without further ado, I would like to hand over to Mr. Lee. Mr. Lee, are you ready?
Yes, I'm ready. Thank you, Ms. Wong, for the kind introduction. My name is Teng Kiat. I'm from MICCI. I'm one of the General Committee members of the MICCI. Now, allow me to do a little bit of introduction about the Malaysian International Chamber of Commerce and Industry. Well, the Malaysian International Chamber of Commerce and Industry, or MICCI for short, is Malaysia's longest established and leading international business chamber. The chamber traces its history from the formation in 1837 of its senior ancestor, the Penang Chamber of Commerce and Agriculture. This was a period where a number of chambers of commerce in the Asian region came into being. And following amalgamation with the Perak Chamber of Commerce and the Selangor Chamber of Commerce early in the 20th century, the enlarged chamber was restructured in 1974 as a company limited by guarantee and renamed the Malaysian International Chamber of Commerce and Industry, or MICCI, in 1975. The chamber represents about 1,000 business organizations in all sizes, both MNCs and SMEs, and covering over 33 nationalities and all types of business activity, including manufacturing and commercial and professional services. The MICCI's objectives, it is to promote, facilitate, and advance free enterprise, international trade, commerce, and investment in Malaysia. MICCI supports all its members through an active program encompassing regular dialogue with government ministries and agencies on matters of significance to the business community, business networking, information gathering and distribution to its members, and capacity building for smaller companies seeking to internationalize their activities in the new competitive global business environment. Malaysian companies of any size can join the chamber and make use of MICCI's extensive range of services, facilities, and international linkages, and its 168 years of experience and accumulated expertise to develop their businesses. Now, today's webinar session is about data privacy and personal freedoms in the COVID-19 pandemic. It will be 1.5 hours. We have two established and distinguished speakers who are here to share their views, valuable inputs, and we hope this seminar will be of use to you. Just as a matter of introduction, the COVID-19 pandemic has brought about a lot of changes in lifestyle, and there is everyone giving everyone some time to reflect, how, the life is to be conducted in light of all these restrictions. Well, there were good news, there were bad news, and various industries, and generally everyone is picking out the pieces and going back to normality, right? To regenerate the economy. And amidst all the MCOs, then subsequently the conditional MCO, and now the recovery MCO period, there are some confusions or nagging questions where people are too afraid or do not know or do not wish to ask, including matters surrounding data privacy. Let's take an example. When you walk into a shopping complex or an office building, and then you have to go and scan your phone, the QR code for MySejahtera. If you don't have, you have to go and fill up certain details. And if you are not filling them up, they probably will not let you in. Or you don't scan, they won't let you in. And they give you a free basic medical checkup in the form of temperature, take your temperature and so on, and put down your personal particulars. So you wonder how safe these apps are. You wonder where your data is going. You've given your IC at times, but now there's no need for an IC. You've given your phone number, you've given your full name, and they know when you get into the building. So how long do they have to keep all this information? And when do they destroy it? Will they destroy it? And then will they, even worse still, recycle their information? And what happens if they do that? So so here the speakers will be addressing some of these concerns. And if you have any of these issues or any of these concerns, please do not hesitate to put them down in the Q&A, and they will answer them during the session as we go along. So so without further ado, I'll introduce the first speaker. The first speaker for this session is Dr. Moon Yati Yatid. Dr. Moon is a senior analyst at the Institute of Strategic and International Studies, ISIS for short, in Malaysia. Her expertise lies in areas related to technology and innovation, with a strong interest in digital society. This includes the nexus between the information disorder, society's well-being, new enabling technologies vis-a-vis digital privacy concerns. She has presented and published her research findings domestically and regionally. She holds a PhD in human-computer interaction from University of Sydney, Australia, with her doctoral research work focusing on humans' mental, physical, and social behaviors and their interactions with collaborative software and hardware tools. She obtained her bachelor degree of engineering in design and information sciences, with a dissertation on integrating culture in designing groupware from Wakayama University of Japan. So Dr. Moon will be presenting her paper with the title COVID-19 Apps, Privacy and Security Vulnerabilities. Dr. Moon, please take over the mic and present the paper now. Thank you.
Thank you, Mr. Moderator, and thank you, organizer, for inviting me to this sharing. So as Mr. Lee has mentioned, my topic today is COVID-19 apps, privacy and security vulnerability. So since COVID-19 started to spread, countries globally are putting various measures to combat the health crisis, which the WHO has declared a pandemic on 11th of March. So in Malaysia, since the government implemented the MCO, the growing technology in our lives is observable. This includes the usage of conference calls to carry out otherwise ordinary work-related and social interactions, the use of e-learning to ensure continuity of students' education, Even funerals were carried out online during MCO. So besides this technology to assist our daily lives in the what people nowadays call new normal, technological tools are being developed to fight the pandemic. And one of them is mobile phone applications or apps. So COVID-19 apps are typically mobile software applications that use digital contact tracing in response to the COVID-19 pandemic. And that is the process of identifying persons who may have been in contact with an infected individual. So to date, there is at least 43 countries that have developed COVID-19 apps. So you might ask, like, why are these sudden concerns on these COVID-19 apps? Because we practically use apps daily, from online shopping to e-hailing. So the reason behind this is that the increasing number of governments around the world endorsing and even in a specific condition enforcing people to install the COVID-19 apps. Among the concerns are the issues of mass surveillance, data storage security, concerns of the misuse of information collected that might lead to violations of privacy and human rights. Some of the concerns, some are also worried that if the government subcontracts the creation of the app and data storage to third parties without specific legislation in place, so what kind of abuse will it lead to? And because these data collected are personal data, and like once a personal data is collected, there is a real danger of it being shared and used for purposes other than health tracking. And it also exposes a potential backdoor into our data and information that may be exploited. So are these concerns on apps or surveillance technologies being implemented during the pandemic, are these concerns real? So observing how countries implement these surveillance technologies, the fear that they can be exploited and the privacy that can be jeopardized is real. So if, for instance, in Israel, new laws have been passed to allow its domestic intelligence agency to monitor civilians beyond basic surveillance, deploying cyber measures typically reserved for counterterrorism. So in China, its surveillance application is imposing very strict instructions to citizens on whether they should be isolated or allowed to enter public areas, in addition to various high-tech systems installed to monitor the population. In Taiwan, if you're supposed to be under quarantine, you would get a few phone calls a day by the authorities to check on your whereabouts. And to ensure that users comply with the quarantine imposed, even if you switch off your phone, somehow turn off your phone for more than 15 minutes, an alert is going to be sent to the authorities, and then they will start knocking on your door. So these demonstrate the possibility of possibly the most pervasive level of citizen tracking deployed, putting privacy and personal freedoms at risk. Further, analysts have also warned that giving the authorities these powers may result in them being reluctant to discontinue the system once the pandemic ends. So how do countries respond to these privacy concerns? There are several different technologies in the smartphone which can be used in order to track movements, such as GPS and Wi-Fi, and telecommunications operators are also handing over customer data which can show the cell towers of phones have been connected to, and therefore triangulate an individual's location. So internet companies are also providing access to location data they have derived. So however, responding to growing privacy concerns, many countries have opted for the Bluetooth technology, and also keeping the apps voluntary for citizens to use. So for instance, Singapore, Finland, and Malaysia, through our MyTrace app, use what we call proximity tracking using Bluetooth. So how this works is that when two phones with this Bluetooth powered app are in close proximity with each other, they will log and keep the data on the phone. So when a person becomes a confirmed COVID-19 positive case, the authorities will access this data on his or her phone and reach out to those people that he or she has come close contact to. So this is beneficial because this enables us to identify who has come in contact, close contact with us, unknown people that we have met in public places. So for instance, in the LRT, at the park, and so on and so forth. However, there's also a drawback with the Bluetooth technology. It has the potential to turn up a large number of false positives. So, and moreover, in order for the app to be effective, a substantial number of people will need to install the app. And as observed in many countries, such as Singapore and Australia, the adoption of voluntary apps tend to be low. The thing about Bluetooth is health experts are less in favor of this model because it makes it harder to spot outbreaks, and it is also harder to follow up for close contacts. But privacy advocates insist this is the most appropriate or most secure. So if we look at Australia's COVID Safe app, okay, so they have this app called COVID Safe. So just a month after it was launched, the contact tracing app has barely been used. And just one person has been reported to have been identified using data from it. So from the reason that, as the numbers of people infected decreased, it also meant that people felt less at risk of infection and less interested in downloading the app. So, well, in short, I guess there is no one perfect design of these tracking apps, and countries, countries globally are exploring which ones are better for them. So some are opting for decentralized contact tracing, which is more, you can say privacy preserving contact tracing, such as the Bluetooth technology. And some prefer the centralized mechanism where data is at a central server, which some may argue, some argue that it is more effective in curbing the spread of COVID-19. So talking about, something closer to home, Besides MyTrace app that I have mentioned just now, so as you are well aware, Malaysia has a proliferation of apps. On the federal level, we have MySejahtera and Gerak Malaysia. And on the state level, there's Selangkah in Selangor. And Sarawak also has its own digital surveillance solutions. So while MyTrace is mainly for contact tracing, Gerak Malaysia was used mainly for monitoring interstate travel during MTO. In terms of MySejahtera, when it was first introduced, it was publicized as a health self-assessment app with a few other functions such as the hotspot tracker for you to enable you to plan your travel and not go to risky areas, and updates on COVID-19 cases, and also advices such as where to head to or what to do when you think you have COVID-19. But since June 1st, the app has introduced a new function, which is the check-in function, to assist with contact tracing after MCO has eased. So since then, I would probably say that MySejahtera is possibly the main app that the government is trying to push. As you can see, QR code check-ins for MySejahtera, everywhere you go. And the government has even announced that eligible Malaysians who will receive the RM50 e-wallet, a credit as part of the ePenjana initiative, would need to download the MySejahtera app. So as per June 25th, 4.9 million users have registered with the app, and about 180,000 business premises have started using the app to check in their visitors. This app, it was launched in April. It has a few success stories. So, for instance, in May, 28th of May, the Health DG mentioned that more than 4,000 people under surveillance, which we call the PUS, and also about 1,800 to 1,900 persons under investigation, or PUI, have been detected through the application. And just recently, in late June, I think it was 25th of June, it was shared that 200 COVID-19 positive individuals were successfully identified by MySejahtera app, according to the NACSA, National Security Council, Mr. Mat Shah. So Mr. Mat Shah also said that the bulk of the positive cases identified occurred in April. So that means that it's not through the check-in applications, but through earlier functions. And also, having said that, Mr. Shah also admitted that there have been attempts to steal the private information, but he has stressed that the security from the government side is strong and handled by experts. So, moving forward, what can the government do? Well, with the growing concerns of Malaysian citizens on data privacy and security of these COVID-19 apps, potentially triggered by global concerns and conversations on the matter. And, not just externally, I mean, internally as well, Malaysia does not have the best reputation of having data protection and privacy systems in place. So just in 2019, just recently, a study by Comparitech ranked Malaysia as 5th worst, out of the 47 countries assessed. And Malaysia has also previously suffered serious data leaks. The then Health Minister, Dr. Zulkifli, said in October that the leak of over 1 million medical scan images linked to about 20,000 Malaysian patient records originated from a local private organization. And also Lawyat.net has reported in 2017 about the online leak of about more than 46 million mobile phone numbers from Malaysian telcos and mobile virtual network operators, as well as breaches of databases belonging to the Malaysian Medical Council, Malaysian Medical Association, and the Malaysian Dental Association. So this highlights that despite the PDPA, severe gaps in data management and protection remain. So I think it's no wonder that Malaysian citizens are concerned about these apps and whether our data are totally secured. So one of the biggest issues surrounding this is that there are just too many questions for us, by us, left unanswered. While there needs to be more communication to remind Malaysians, from the government, to remind us that these apps fit three functions. So one is they should be able to reduce the likelihood of us contracting COVID-19. Two, they are allowing us to resume to our normal lives more rapidly. And three, reduce the spread of COVID-19 in the community. So while that is important and should be carried out, the government should also provide more transparency on government processing of data and other mechanisms of these apps to obtain more cooperation and trust from citizens. There can also be platforms for citizens to provide feedback, open feedback and discussions to improve this application. So for instance, there have been concerns by the business community, where they highlighted that they are unable to gain proof if a customer walking in their premise has successfully registered or not. So perhaps there can be some sort of a mechanism, maybe changes in the app's interface, like a history menu in the app to verify registration. So, and then I think Malaysia also needs to improve on existing data privacy laws to allow data sharing in the public interest with the necessary data security to match. So broad community acceptance beyond formal legal requirements for collocation tracking requires the perceived public health benefits to outweigh the concerns of personal privacy, security, and any potential risk of harm. So to close my sharing, lastly, I would like to provide a key takeaway is that the use of tracking apps comes with the cost of increasing privacy and security risks of individuals and communities. However, applying technology is arguably useful to obtain large data scale data in an efficient and timely manner that in this day and age can save lives. Thank you, and I give back the stage to the Mr. Moderator.
Thank you, Dr. Moon. Well, one of the things that really stand out in her talk was the fact that we are not really ranked very high up. We are ranked like the 5th worst, in terms of data privacy protection and all that. So, well, obviously there are things to be improved over there. And there are also some things that she said about the fact that, some of these apps do not seem to be able to track the history and so on. So it looks like, keep your questions coming, start asking some of these questions and send them in through Facebook. And we will then try to ask these questions and forward it to Dr. Moon for her to ventilate the same. So I will now, for now, I will now introduce the next speaker for this session. Her name is Miss Lin Lee, and Lin Lee leads the IP and Technology Practice Group of Tay and Partners, comprised of a dedicated team of lawyers who are sector specialists from a diverse background. She advises and represents clients from various industries on infringements of patents, trademarks, copyright, industrial designs, and passing off, and has in-depth knowledge and experience in implementing anti-counterfeiting and anti-piracy strategies. For deals and transactions, Lin Lee's broad experience is sought after for work relating to cross-border transactions involving franchising, licensing, technology transfer, and transfer of ownership. Multifaceted, her practice also covers advising and working with local and international clients on the expansion, management, and protection of their IP portfolio, particularly complex trademark registrations. She is regularly engaged by clients for advice on data privacy issues and structuring and implementation of data privacy policy and practices. Her paper to be presented today at this session would be Data Privacy in the Context of COVID-19. Lynn, can you take over the mic, please? Thank you.
Everyone, I'm Lin Lee. I practice predominantly IP law, and I also advise on data protection. So today, after hearing Dr. Munyati on the difficult technical issues faced by the various applications which are now tracking us and storing our personal data, I will now bring you through some of the drier parts of data privacy, particularly during this period. How should you go about processing personal data? I will share my screen because I have some slides so that you'll be able to follow my session easier. Okay. We don't have very long to speak because we would like to allow for more time for Q&A. So I will go through my slides quite quickly. If there are any questions that you have, we can always take them at the end. So as Malaysia enters its second month of the recovery MCO, a lot of businesses have now been allowed to resume operations subject to complying with standard operating procedures, the SOPs that you hear so often. These are issued by regulatory authorities and they are updated from time to time. One of these important SOPs is that businesses must record the attendance and the personal details of their employees and also visitors. So the information which they are required to take down before they allow the invitee to enter their premises is your name, your contact number, the date and time. In the early days of this recording and registration, it was a little bit controversial because it was thought that your IC number was also required. But since the first few weeks, it has been clarified that all which is required by MOH is just your name, your contact number, the date and time of your visit. This is so that they will be able to identify who are all those who are in contact with anyone who could possibly be a COVID-19 patient or a high-risk person. There are two main applications which are used. That is the MySejahtera and Selangor. Selangor is for the Selangor government, and MySejahtera is the one which has been implemented by the federal government, and as mentioned by Dr. Munyati earlier, this appears to be the primary application which is now being used, most popular amongst all the business premises. So one of the challenges faced by businesses and also the individuals themselves is how do I protect my personal data whilst I try to adhere to the SOP. I think one thing which is very important for us out there is that the SOP does not only apply to businesses, but there are also specific SOP issued by the Director General for individuals. So the SOP for the individuals will then govern the individual's behavior, particularly when they visit premises which, for example, hotels, food and beverage, or even your law firms or your accounting firms, banks. All the SOPs which regulate these businesses must be adhered to by the individual, because the SOP which applies to the individual requires that the individual comply. So in that circumstance, perhaps it may be a misconception for individuals to think that if anything were to go wrong, then the businesses are the ones who are liable, because the individuals themselves have a duty to undertake under the SOP issued to them. Okay, so in order to help the businesses to regulate the amount of information that they can collect and also adhere to the Data Protection Act, an advisory was issued on the 29th of May. So the advisory guideline as to what is required to be collected, a few things such as how long you can keep the information, and it also provides a few samples such as privacy notice. Okay, it is important to understand the scope and application of the PDPA when you are processing personal data. So who does it apply to? PDPA applies to everyone who processes personal data in Malaysia, or if you use any equipment in Malaysia to process the personal data. So this automatically excludes anyone who is processing personal data outside Malaysia. So if you are processing personal data outside Malaysia, then you will not be within the scope. And also parties who are not within the scope of this piece of legislation is your federal government, your state governments, and you have some organizations, the credit reporting agencies, and also some exemptions, such as when you process personal data purely for personal affairs. So in this situation, you will not be governed by the Act. But in general, businesses who process personal data will have to come under the scope of PDPA. So what is the personal data which is covered? The personal data is defined as any information in respect of commercial transactions that relate directly or indirectly to an individual who is identified or identifiable from other information. So the personal data will include sensitive personal data. Okay, sensitive personal data will be data such as your health and mental condition, your any record of commission of offense, your social, your political and religious beliefs or similar beliefs. So those will be your sensitive personal data. Everything else relating to you, including your favorite color, your favorite movie, that is all personal data. Okay, so in our situation, we have personal data, which is your name and mobile number, date, time of visit of a particular location, and you also have sensitive personal data such as body temperature reading. Okay, if it is a personal matter, then the PDPA will not govern it. But if it is anything to do with something which is of a commercial nature, whether or not it is contractual, so long as it is a matter relating to the supply and exchange of goods or services, an agency service, investment, financing, banking, and insurance service, that particular transaction where you have personal data being exchanged would be covered by your PDPA. Okay. So processing under the Act is very wide. It actually basically covers everything that you do relating to personal data. So as you can see here from the slide, the moment of collection, even if you do not record or you do not save and you do not store, it is already processing. So you cannot even collect if you do not fulfill the requirements provided under the Act. These are the three main players that you would see under the Act. You have the data user. So the data user will be the person who processes the personal data, or he authorizes another person to do so. So that would be the persons who collect data from you, such as the restaurant you visit, or any business premise that you enter. The person who collects it from you will be the data user. Okay, and of course, in our situation, the government, federal government and state government will also be the data user, because they are the ones essentially who will be accessing and processing the data. The data subject would be your individual who provides the personal data. Then you have another category which is called the data processor. So your data processor is a person who processes personal data on behalf of the data user. Okay, so he does not process personal data for his own purpose. So these would be parties such as your app developer or your service provider for servers. So anyone at all who provides data processing services on behalf of a data user. So that is a data processor. So the PDPA now, as it stands, governs the obligations of a data user. Okay. So what are these obligations of this data user? What must they do when they are processing your personal data? Enshrined in the Act is 7 principles which must be adhered to. You have your general principle, your notice and choice principle, the disclosure principle, security principle, your retention principle, your data integrity principle, and your access principle. The general principle is the mother of all principles in the PDPA. Okay, the general principle provides that when you process personal data, it must be for a lawful basis and it must be purpose-driven. What does that mean? It means that when you process personal data, you must have a justification for it. Why are you doing it? Okay, the most common basis for processing data, personal data, is that you are allowed to do it, so it's lawful because you have obtained the consent of the particular individual. So that is one type of lawful basis. There are several other bases, but this is the one which is most common. Okay, and what is the meaning of purpose-driven? Purpose-driven means when you process a personal data, it must be for a purpose for which the consent was granted. So for example, an invitee comes to your shop and you ask for his name and mobile number, and you ask him to write down that he arrived at this time on this date. He will then, what is the purpose of this? You will then explain to him that this is required because I have a SOP to follow. The SOP has been issued for my industry, and this is what I need to collect. Okay, so that is the purpose for which you are collecting his information. So that is the meaning of purpose-driven. So that purpose is fulfilled when the information is provided, and you only use it for when there is a request by MOH to provide the information to MOH. This is an example where you record the information on a logbook. Can you contact that person because you have his name, his mobile number, and in fact, when he orders his food, if it is a restaurant, you will also know what he enjoys. Are you able to use this information for any other purposes? The answer is no, because under the general principle, it must be purpose-driven. So what was the purpose for which it was collected? It was for contact tracing. and because you are complying with your legal obligation under the SOP. You therefore cannot use it for any other purpose. Okay, so that is the meaning of purpose-driven. So for consent, you have two types of consent. Generally, there is the normal consent for personal data, and for sensitive personal data, they have this thing called the explicit consent. Explicit consent should be a consent which is in writing. For consent, it can be implied through action, or it can be in writing. These are the other lawful basis for which you can process personal data, where you have the performance of a contract. So in order to carry out the contract, you need to make use of the individual's personal information. You have to disclose it, you have to process it. So that is fine. Or if you need to comply with statutory health and safety obligations, such as during this COVID-19 pandemic, where you have to comply with the Prevention and Control of Diseases Act, where SOP has been issued. So this is one lawful basis. Or if you are protecting the vital interests of the data subject. So vital interests would be, for example, life and death situations, emergency situations. So if you are able to rely on either 1, 2, or 3, for example, then you don't need the consent of the individual in order to process the data. So during a COVID-19 or a pandemic situation, you can always rely on for 2 or 3 in order to process the personal data, but of course for a very specific purpose. So I'll just move on. I've already explained this. Okay. It is also very important that the personal data which you process, so for example, it will be, let's say we collect personal data, it must be adequate. So what you need to collect must be sufficient, but not excessive in relation to your purpose. So in our situation, what is adequate would be what the advisory says you should collect, right? So the advisory clearly says, please only collect name, mobile number, date and time. Okay, do not collect anything else. If you do, it will be considered excessive in relation to that particular purpose. If you require to collect beyond name, mobile number, date and time of visit, for example, if you are you retail clothes, you may want, in addition, since they are filling up their personal particulars, you may want them to provide you with certain information about themselves, their preference, their style or fashion design preferences. Okay, but that is not mandatory for contact tracing. So if you wish to obtain that information from them, they must give you consent. Okay, but in our case, what is considered adequate for purposes of contact tracing is just that 4 pieces of information. Okay. Second principle, which is very important under the Act, is the notice and choice principle. Okay, the notice and choice principle is what gives birth to your privacy notices. I'm sure all of you would see privacy notices now everywhere. It's been many years since our PDPA came into force. So written notice must be given to individuals, both in English and Malay. And this notice must contain certain information. Okay, it must contain information such as what is going to be collected from you, what sort of personal data will be collected from you, what is the purpose for which they are collecting this personal information, and then what they intend to do with it, and who they intend to disclose it to. Okay, so these are the important information which must be in any privacy notice in order to comply with this principle. And of course, if possible, the notices should always, not if possible, in fact, you should always display it very conspicuously, so that before anyone provides the information, they would have seen the notice and be aware. Okay. So the third principle is the disclosure principle. It is a bit repetitive of the first and second principle. It actually provides that personal data may not be disclosed without the data subject's consent, okay, for any purpose other than that disclosed in the privacy notice. So if the privacy notice says the purpose to be used, the purposes for which data, the personal data may be used is for purpose A, B, and C, then you can only use it for A, B, and C. And if the privacy notice says that the data can only be disclosed to party XYZ, then it can only be disclosed to party XYZ. So that is the disclosure principle. Okay. In this case, the disclosure principle was collected for contact tracing. So you cannot use it for any other purposes unless you have obtained consent or you are able to justify with other types of lawful basis. This is the sample privacy notice, the English version, which is provided in the advisory. So you would see here that it says the collection of your details is required under the Prevention and Control of Infectious Diseases Act, and it is hereby compulsory. So this is the purpose, okay, for which the information is required. And then what is the type of information? You have to give your name, contact number, date and time of arrival, okay? And then another important aspect of a notice is if it is mandatory, as it is here, you must inform them of the consequences of not providing such information. So in this notice, you will see that it says failure to provide such information, we may not be able to offer our services to you. Okay, so if you were to go to visit any store, you would find that they will ask you to register. Otherwise, they will not give you entry. So that is their right, because that is the SOP that is mandatory for them to comply with. If you do not, if they allow you in without the registration, they will be in breach. So if you refuse, then the notice tells you that they will not be able to provide such services to you. This is the Malay version. Okay, then the following one is a security principle, which is very important, but the laws just says so much, but what actually happens depends a whole lot on the organization itself. And I think Dr. Munyati would be the best person to advise on what are the steps that one can take in order to ensure that the personal data is, the security of the personal data is intact. Okay, the security principle provides that all data users must take practical steps to protect the personal data. How do you do that? Okay, you must take technical steps, number one. Number two, you must take organizational steps. Okay, what are technical steps? Technical steps will be your IT system. It has to be, you have to have a IT system which will prevent unauthorized access or accidental destruction. And then you must have organizational measures, such as if you have data in hard copy, then storage is very important. It must be under lock and key. Restriction to those areas where personal data is stored must be limited to only persons who require access because of their employment, because of their role in the company, or it must be access card protected or passcode protected. Okay, so those are organization measures. So the advisory also provides a suggested format for you to provide your information. Sorry, I'll carry on. Okay, the next one is the retention principle. The retention principle provides that once you have collected and processed the personal data, how long can you keep that information? Are you able to retain it for 10 years or only 2 weeks? So what is the period of time? Okay. Again, there is very little guidance on this, except that during this period, the specific information that is collected for purposes of contact tracing must not be kept for longer than 6 months after the end of the particular CMCO or RMCO period. So this 6 months is a useful and helpful way to guide business premises as to how long they must keep the records. Okay, because there are situations where legal action could be taken beyond 6 months, but if they do not have this information, they cannot be subject to any offences under the PDPA because the advisory has provided the retention period, and in this case it is 6 months. Okay, we move on to the sixth principle. This is the data integrity principle. The data integrity principle is one which says that the information that you collect must be kept accurate, complete, and up to date. So it must not be anything which is misleading. And finally, you have the access principle. The access principle provides that data subjects have the right to access, to view, and correct their personal data. However, this principle does not apply in this COVID-19 pandemic. So the advisory provides that the access principle is exempted. So what that means is, in an ordinary case, the data subject or individual would be able to ask the data user to provide him with the personal data that the data user is holding. So a data subject can go up to a data user and say, I know you have information on me. May I have a copy of it? Okay, so you, in the ordinary course, the data user's obligation would be to provide the data subject. But in this case, as you would note by now, all your check-in information cannot be retrieved. Of course, if you're talking about logbook, then yes, you can flip through the pages and hopefully find your name there. But if you're talking about scanning the QR code and after you hantar your information, there is no way in which you can retrieve it. Okay, and it is also clear under MySejahtera, if you look at the FAQ, they actually inform you that you do not have that the only party who has access to the information is MOH. Okay, so that is the end of all the principles. So I'll just briefly tell you what happens if you do not comply, and also whether you have any remedies. Okay, unfortunately, the PDPA does not provide for any civil action. Okay, what that means is you don't have any right to compensation if there has been any breach of your rights as a data subject. Okay, what you can do, of course, is you can lodge a complaint to the commissioner, and then it becomes, if a case is open and investigated, then it becomes a criminal offense under the Act. Okay, so if you breach any of the personal data principles, it is an offense, and on conviction, the penalty is a fine of not exceeding 300,000, or a term of imprisonment not exceeding 2 years, or if it's bad enough, it could be both. If you are a body corporate charged and convicted, then anyone who was a director, a CEO, or senior management may be charged severally or jointly. Okay, unless the offense was deemed to have been committed without this person's knowledge, consent, or connivance, and he had taken reasonable precautions and due diligence to prevent commission of the offense. So it is important to have a very good compliance officer to safeguard your senior management in the event there's any breach. Okay. And just some concluding words. I think now it's really high time for people who are not familiar yet with PDPA, especially businesses, not only during this time of COVID-19, but at all times when they are processing personal data, to remember that they have certain duties and obligations. And it is not to be done, that processing personal data is not something which you can take lightly, because there are very severe consequences. So you should be mindful of your obligations, and enforcement of the personal data protection by officers are constantly ongoing. So what they do is they will conduct inspections from time to time, and not only upon a complaint. And we are aware that they are monitoring compliance, and they will also carry out the necessary enforcement actions. Okay. So thank you. That's my session that I have to share with you today. I pass it back to Tin Kiat.
Thank you, Lid, for the enlightening talk about data privacy laws. Now, we have some questions that have come in, and there are also some questions that came to us earlier on before the start of the session. And two of the questions would that I'm going to read them out now, and they are probably the questions that could answer some of the questions that has come in the Facebook in the Facebook messages. So one of the questions generally put is this: if the official apps such as MySejahtera, Sri Lanka, MyTrace, which are government apps, how secure is this data, and whether the data will be abused? So that is the first question. And related to that question is that when MySejahtera apps records and evaluates somebody's risk, whether it's high risk or it is, when somebody is graded as risky, and thus may be denied entry to many places and even labeled as such that you are a risk to the area. So what recourse do you have? Do they have the right to deny entry and to deny you entry? And what are your recourse? So I think these two questions can be combined into one, and I believe Dr. Moon can assist us in answering those two questions. I'll come to the other two questions later on, which I think will be attended to by Lynn later on. So for now, it's Dr. Moon, yeah?
Sorry, I had a little bit of technical glitch. So if I may recall, you were asking about the apps, were you? About the
Yes.
security, data security, right?
Yes.
Okay. Yeah. So I think I have somehow answered the first question in my sharing, that we don't know for sure. Hence, the issue of privacy and security is a global concern. Government bodies in Malaysia through their website and media engagements have communicated that they are ensuring the security of users' data from being misused, and that the data is regulated and only accessible to relevant parties, and will only be used for the purpose of managing and mitigating COVID-19 outbreak. So it has also been communicated that the apps are owned and operated by the government of Malaysia. The government also assures that the data collection and the data usage will be in accordance with the government's information security standard. So it has been communicated that a data captured will be strictly time limited. So for instance, MySejahtera, if I'm not mistaken, the data will only be stored for 90 days and will be purged thereafter. And for MyTrace, if I'm not mistaken, it's 21 days. So further, according to CEO of NACSA and also MKN, Mr. Mat Shah, I mentioned just now, he has admitted that he has seen, the apps that has seen its own share of hacking attempts by malicious parties who are trying to steal the private information of its users. So though he stressed that the chances of it being hacked are thin, considering the fact that the app is, it has strong security managed by experts. And also it has multi-layer security. He also shared that a team from Mampu focuses on the development, while NASA focuses on security, and the Health Ministry oversees its use. However, the fact that some countries have a history of abusing the data collected, and even though Malaysia's PDPA is in place and it's meant to be the vanguard of protection and information collected of an individual, the PDPA only protects against inappropriate use of personal data for commercial purposes, like Lin mentioned, and does not apply to government. So which increases more concern on the issue. So I hope I have answered that question. So on the other question on whether my MySejahtera app has a, what happened when is the risk factor based on where you go, and so by some fluke you may have graded as risky and thus deny entry to many places and ostracized, and what can you do about it? So MySejahtera users who are currently classified as persons under surveillance, or PUS, persons under investigation, or PUI, casual contact or close contact, will receive a high risk status. So similarly, non-MySejahtera users will also receive high risk status if they have answered yes to the health declaration in the check-in registration page. So while currently there are no rules, no rules have been set to deny the entry of the visitors. Entry into the premise for high risk visitors is dependent on the particular premise policy. So if you think that there is a mistake when you are graded risky, you can seek for more clarification from the MySejahtera support. I believe they will get back to you immediately. And also, I think this question highlights my point previously in my sharing that there needs to be more transparency and a platform for feedbacks and discussions, so that when there is a mistake with the app, it can be immediately highlighted and improved. So because we don't want technical glitches or inappropriate design of the app leading to this kind of issues. Thank you.
Yeah, thank you for the answers. There are some questions that are related to what Dr. Moon has answered. I'm referring to a question from Tan PS. In fact, it is a comment by the person to say that to demonstrate compliance, it is best to register either manually or via private QR code methodology. And Tan PS further commented that for organization that needs to provide daily update to relevant authorities, you can quickly pull count without having to provide detail. MySejahtera doesn't support data drilling. I think this is correct. The first, based on what the speakers have presented, yes, if you already have your own SOP, I'm sure that everybody have their own SOPs, in various industries. For us lawyers, we also have our own separate SOP, which is more specific to the industry. So if you are required to come up with your own data, and to produce it before the authorities, yes, it is correct that you should have your own manual record or have a private QR coding methodology, so that you can pull up those data when the authorities need to see them. So, and as correctly pointed out, MySejahtera does not support this feature of you having to be able to pull out this data and pass it down to the authorities. So I hope that answers the concern of Tan PS over there. Okay, there are two other questions, moving on, that came in also earlier before the start of the session. So one of them is that senior minister said it is not mandatory to use the apps, but retail outlet insists. And with this confusion and police making raids by asking patrons to show proof of registration, uh, otherwise are they personally liable for the fine of 1,000 ringgit? So is the outlet or the patron or both that are liable? Okay, and related to that question was another question to say that there are outlets who choose their own QR codes and registration. So again, this comes to data privacy. What assurance do we have as data subject that they won't abuse those data that they have already collected and processed? So I think these two questions are meant for Ms. Lee Lin-Lee to answer. So hopefully you could throw some light to it. Yeah, Miss Lee.
Yeah, hi. Thanks, Tinket. Well, on the first question, yeah, it is true that it is not mandatory to use these apps, although it is mandatory under the SOP for you to provide the registration details before the business outlets will allow the invitees to come in. And then the second question related to that was that who would be liable if such information was not provided by the invitee, and yet the invitee is found in the outlet. So there has recently been a lot of news on social media where people complain that they have been allowed into, again, I will use the example of a restaurant where they did not provide the registration details. Either there was no logbook or they have scanned the QR code and submitted the info, but when questioned, they are unable to provide evidence that they have done so. Okay, so who would be liable? Okay, on the assumption that there is no registration, okay, and not that you cannot prove you have already registered, that would be a separate thing altogether. Let's say you have not registered, but the outlet allows you inside nevertheless. So what happens? Well, I mentioned earlier during my presentation that both should actually be liable because both parties, the individual and the outlet, would have received their own SOP. So contrary to popular belief, every individual now has that individual legal responsibility of behaving themselves and conducting themselves appropriately. And that includes providing the information which is required before you enter. So stretching this further, you could say that if the outlet does not have the facility, does not facilitate this provision of information, has no logbook, has no QR code for you to scan, then it is best you do not enter the outlet. Okay, so if the police were to come, they are entitled to question both parties, and of course there is presumption of innocence until proven guilty. The law is currently not drafted as a presumption of guilt, it's presumption of innocence. So whatever it is, if they find you on the spot, I would think that is irregular. You should be convicted in the court of law, or you plead guilty, then only they are able to fine you. But in terms of who is liable, it should be both parties because both are complicit. Okay. The second question, I think, is whether you can use your own QR code. The answer is yes, and also as commented by our moderator, Tinket, who picked up some comments by PS Tan, I think it is very wise to actually have your own record so that if you are questioned, you are able to produce it very quickly to clear your name, so to speak. If you rely on MySejahtera, I think it would be some time before you are able to get the information to show that you have properly recorded the details. So I believe certain malls like Mid Valley Mega Mall, if I'm not mistaken, they use their own app, so then they will have access to the information. Or you have many places, smaller business owners, I would assume, who have their own logbooks. So then these logbooks are kept by them as evidence of proper registration. Will there be abuse? Well, the PDPA is a compliance legislation, so any sort of investigation will then ordinarily be triggered by a complaint. So we would not know of any widespread abuse until there are widespread complaints. But I would, of course, caution all businesses who are collecting information that they must comply, even though it may appear that without a complaint there will be no investigation. They should be allowed to use their own form of registering the details. That one definitely, but they must comply with those principles that I mentioned earlier, including ensuring the security of the logbook, how long you can retain the logbooks, etc. So yeah, thank you. I think that is my response to the questions. Over to you.
Yeah, thank you, Lindy. There is one question. This is more or less like a cross-border question, actually, that came from Shanti Balachandran. She has asked, for those flying or entering into Malaysia, there are more information to be provided. Do we have any right not to furnish information? What is adequate information in that instance? I think this question, probably Dr. Moon, would you like to answer this question?
I think that's more legal. Probably Lindy will be better.
Yeah, okay, sorry about that.
Yeah.
Okay, the information that is required for different sector industry is on the whole the same, except that certain industries may have slightly stricter SOPs, and the SOPs are easily available on the internet of the various authorities. So you should be able to verify whether or not that information is required. I think at the very least, you should be given the opportunity before you provide the information to check whether they have the right to collect before you actually provide it. So in the case where you are very uncomfortable to provide all the information which is stipulated, what I can say is I suggest that you either ask them to show you, or if they are not helpful or cooperative, perhaps you could quickly verify by yourself on the net. It may sound something like a suggestion which is not practical, but I find that finding the SOPs on the internet not difficult before you provide the information. So I would imagine that not everyone would be able to say that every business will collect the same or different information. But if you fly in, I can imagine the information that they will require may be slightly more than just someone local visiting a shop.
All right.
Yes.
Okay.
Over
There
to
are
you.
two other questions related to PCIDA and PDPA. Now, PCIDA is a short form for Prevention and Prevention and Control of Infectious Diseases Act. So, and the question here is that can PCIDA override provisions of the PDPA? And related to that question, there was also a question to say, My Sejahtera refusing access, then are they in contravention of the PDPA? Perhaps I could, based on the slides that were presented, perhaps I could answer that question, and along the way, maybe Lynn could also assist or add on if necessary. Now, PCIDA is a specific legislation that is used because of this current pandemic. It is the COVID-19 pandemic, and it is used to ensure that there is control. People are not moving freely as before, so that we can contain a certain epidemic or a pandemic. So whereas PDPA is Personal Data Protection Act, and that is a general legislation to control the use and to prevent any abuse of personal data that are being collected, and the ways and means of obtaining the consent and processing such data. So One is specific and the other is PDPA. Let's say, this COVID-19 is over. While the PCDA is no longer relevant for that point in time when the whole COVID-19 or other epidemic is over, um, the PDPA continues to apply because it's about data protection. You don't simply, process some other people's data. And coming to the other one about MySejahtera refusing access. Now, I think here there's a small clarification we have to make. MySejahtera is an app that is used for contact tracing, and everything is reported to the MOH when your data is being logged in as you check into a particular place using MySejahtera. It's for ease of contact tracing, whereas PDPA, as I explained earlier, it is about data protection, and one is about an apps, for facilitating MOH, and also ease of you entering into the place where you want to go. And the other one is about an obligation under the law that is ongoing. So Lynn and Dr. Moon, perhaps you guys would like to see whether there's anything to add to what I said.
Perhaps just one word on whether PCDA overrides PDPA. Well, in a limited context, maybe you can say yes, it overrides PDPA, but on the other hand, that is not entirely accurate. PDPA is a legislation which regulates data processing. So one of the very important requirements under PDPA is lawful basis of processing the data. So in this situation, PCDA gives a lawful basis for processing the information such that the data commissioner has exempted one entire principle from applying, which is the access principle. Okay, the access principle is actually very important because it allows the data subjects to review the information which is being held by the data user, and that is connected to the data integrity principle, which then is an obligation to ensure the data which is kept and held by the data user is accurate. So they are connected very closely to each other. But in this case, because of the COVID-19 pandemic, the PDPA commissioner has issued an advisory which provides that, okay, the access principle is exempted and consent is also not applicable anymore under general principle, because we are now asking people to provide the personal data for what lawful basis? It was for the basis of complying with health and safety regulations. So that itself is provided in the Act. So while you can say it overrides, but actually they are sitting harmoniously next to each other. So the PCDA is actually anticipated, or what can transpire under PCDA is actually anticipated under the PDPA. So that is my response to whether PCDA overrides PDPA.
Well, thank you very much for the add-ons to what I've already answered some of these questions. I think the takeaway from this this webinar is such that, well, you may have your apps, as a business owner or premise owner, for ease of people to go in and out. But if you have your own SOP that is issued by MKN that you need to comply, so you need to comply with those SOPs when they require you to key in your name and your phone number, and also the time in and time out. You may use your own apps, and MySejahtera is an app that is easy for people to, to scan their QR code and then push this up to the MOH. And there's Lanka, there's MyTrace, but we should also keep our own record if it is if it is something that you want to feel comfortable in case the authorities come and decide to do a spot check and say who has come in and who has left this place. And otherwise this would you will bear the risk of being of committing an offense under those regulations, which I think we have mentioned is a fine of up to 2,000 or imprisonment of 6 months or both. So this is one of the points that we have brought up. And secondly, of course, those apps were really something that is meant for their own purpose. It may not be adequate for your purpose, so you will have to come up with your own. And the third thing, if you feel that your data is going to be violated, you are not comfortable with going into those places, because you think that they are going to recycle your information. So the choice is really yours, whether you want to go into this shopping complex or go into this office, and to see whether you can, you have the choice to go or not to go. So if you want to go in and you comply, and I think everything is good. But if you don't want to comply and they don't let you in because they are the premise owner, I think they are entitled to do so. The only avenue you have is that you can try and check against the regulations. If the regulation says that they do not need to ask for so many information, and you challenge them and you say, I want to go in, I think you will have a chance. But how many of us actually do that? You just walk to the next shopping complex or to the next office tower or whatnot, or tell the guy that I cannot go into your office. So so I think these are some of the takeaway. And if there are some further questions that people would like to ask, yes, MICCI has a website, and we are more than happy to address some of these questions. So with that, we thank you very much. We thank Dr. Moon and Ms. Lin Lee for the enlightening talk and answering some of these questions that has come up from viewers of this webinar. So I will now hand over to Ms. Wong to close this session off. Thank you.
Thank you, Mr. Lee. Thank you, everyone, for tuning in. We have come to the end of today's webinar. Once again, on behalf of MICCI, I would like to thank Mr. Lee for moderating the session, Dr. Moon and Ms. Lin Lee for the very enlightening and comprehensive presentations. Thank you all for tuning in. We'll see you again soon. Bye-bye.